afternoon. Good afternoon, everyone. I'm Donna Martinez. Welcome to the John Locke Foundation. Wonderful to have a full house here in downtown Raleigh, and welcome to all of you who are watching us on Facebook as well. So glad to see you here. Now, we have folks who are here with us who we have seen before, who are good friends of the John Locke Foundation and who are regular attendees here at our Monday Shaftesbury Society. But we know because of the topic and the issue that we have a lot of new folks in the room as well, some who may not have attended before. And of course, we hope that based on today that we will see you again here. So for those of you who are new, you might be thinking, gee, the John Locke Foundation, normally we would think of you as a free market public policy think tank. Of course, that's correct. You might think, well, we normally hear you on economic issues, on regulatory issues, and of course that is accurate. But the John Locke Foundation is also very interested in issues related to law, regulation, and criminal justice reform. Overcriminalization is at the top of that list, and that's why we wanted to hold this special presentation today. So we hope that today you may find out something new about our views, and in fact, if you're interested in learning more, we have a couple of pieces for you on the table, written by our Director of Legal Studies, John Guzet. John, are you in the room here? I think he was in the hallway. There's John right there. John, raise your hand, please. John is an attorney himself and a legal expert, has been doing writing on this and many other issues. A couple of his pieces are in front of you. Also wanted to quickly just remind you, since there are so many folks in the room who are involved in criminal justice and the legal system, we are holding another event about a month from now on May 7th. You have a flyer about this. This is a panel that we are hosting along with our friends at Western Carolina University, the Center for the Study of Free Enterprise there, looking at the issue of how we select judges in North Carolina. A variety of viewpoints represented by a number of very distinguished academics, and we hope that you will want to attend that. That's going to be moderated by Ed Lopez at Western Carolina University. It's a special presentation across the street at Campbell Law School Auditorium, and for that particular presentation, there is a $15 entry fee to cover lunch. Normally, this gathering here every Monday is free and open to the public, so we hope you'll attend. But we thought that you might be interested in May 7th as well. If you are, and if you'd like to purchase a ticket, you can do that on your way out with our Cindy. Where is Cindy? Right there in the corner of the room. She can get you a ticket, or you can do that on our website. So all of that taken care of. Let's go ahead and get to today's presentation. So thinking about a messy criminal code, do you think it doesn't matter? Well, think again, says our special presenter today, Professor Jessica Smith. North Carolina's lack of a streamlined, comprehensive, orderly, and principled criminal code creates costly inefficiencies in the criminal justice system. It creates opportunities for unfairness, and it undermines the effectiveness of the criminal law. So today, Professor Smith is going to talk with us about why all that is and what we can do to change that. Many of you in the room today, of course, know that Professor Smith is renowned in her field. We're so thankful and honored to have her here with us today. She joined the Institute of Government in 2000. She also clerked for U.S. District Judge W. Earl Britt in the U.S. District Court for the Eastern District of North Carolina, and also for Senior U.S. Circuit Judge J. Dixon Phillips, Jr. in the U.S. Court of Appeals for the Fourth Circuit. At the School of Government, Professor Smith teaches and consults with judges and other public employees in the criminal justice system. A couple of years ago, in 2015, she was appointed reporter for the Criminal Investigation and Adjudication Committee of Chief Justice Mark Martin's North Carolina Commission on the Administration of Law and Justice. So she is indeed the expert, and we're very honored to have her here with us today. Other thing I'd like to point out to you, I mentioned John Guzet. I also want to mention to you two other folks within our organization here at the Locke Foundation who are doing all sorts of work on this issue of justice reform. That would be Becky Gray and Lexi Arthur. Becky and Lexi, there's Becky in the corner, and there's Lexi. Any questions about the Locke Foundation's views on this and work that we're doing, feel free to talk to these folks after the presentation. But for now, please join me in welcoming to the podium today Professor Jessica Smith.
Good afternoon. I see there are some people outside the door, and there are some empty seats here. I'm just talking about criminal law. I'm not a criminal. It's safe. It's safe. There are safe seats up here. Okay, no takers on that. Well, I'm happy to be here. Thank you for coming. I will admit to you that I am pretty much a full-blown 100% law nerd, and topics like this get me extremely jazzed up. I have a little bit of common sense, enough to know that maybe not everybody sits where I do on the nerd scale. So to make this topic engaging this afternoon, we're going to play a game, true or false. The rules are extremely simple, very simple. I'm going to make a statement, and you're going to tell me whether the statement is true or false, okay? The first one needs a little bit of lead-in, the others don't. Here's the lead-in that we need for the first statement. In the North Carolina general statutes, there is chapter 14. It's entitled Criminal Law. It's long. I have it with me. It encompasses, quite a number of pages. It's pretty thick here. And it covers a variety of things. It sets out serious offenses like homicide, first-degree murder, and second-degree murder. It prescribes offenses like rape and sexual assault. It prescribes property offenses like larceny and receiving stolen goods. It also sets out gambling offenses and prostitution offenses and weapons offenses and trespass offenses and so on. That's my lead-in. Now for our first true or false statement. Based on what I've told you, you're going to tell me if this statement is true or false. If you were to read chapter 14 in the general statutes entitled Criminal Law, you would pretty much know most of the things that have been made a crime in North Carolina. That's the statement. How many people would be willing to say that's true? Nobody's willing to say it. How many people say it's, okay, I got a couple. How many say it's false? How many say it's false? Okay. Well, you should be very proud because you got the first question right. There will be no grade. There'll be no grade on this, just so you know. The answer is false, and it's false for a number of reasons. First, not all of the things that have been made criminal are actually found where you'd think they'd be, which is in chapter 14, which is entitled Criminal Law. In fact, in our general statutes, which are many volumes of green books that I'm sure many of you have, felony offenses are peppered throughout 53 separate chapters of the general statutes, and misdemeanor offenses are peppered throughout 142 separate chapters outside of chapter 14, which is on criminal law. So that's the first reason why that statement is false. But let's explore that a little bit further with another one. Here's the statement. Got to pay attention. Here's the statement. Although it's not included anywhere in the general statutes, in North Carolina, it's a crime for a dentist to run an ad and not say whether he's a specialist or a generalist. Although it's not included in the general statutes, it's a crime for a dentist to run an ad and not say whether he's a specialist or a generalist. How many people would say that's true? That's a crime in North Carolina, even though it's not in the statutes. Okay, some. How many people are going to say it's false? How many people are going to say, on the rest of you, you're just not willing to participate, right? I told you, it's not graded. It's fine. It's fine. The answer is it's true. It's true. It's a crime. And you might be wondering, how can that be so? It's not in the general statutes. It's not written in our statutes. Well, the answer is that in North Carolina, the law delegates authority to create crimes to administrative bodies and boards. So, for example, a provision in the general statute makes it a crime for a person to violate any rule or regulation that's been adopted by the Board of Dental Examiners, like the one we just talked about. I actually have the statute and the rule of regulation right here. Rule of regulation here. It's a class 2 misdemeanor to run an ad and neglect to include whether you are a generalist or a specialist. But that delegation, I'm not picking on this particular board, it's just an example. That delegation is done to other boards and bodies as well. For example, it's also a misdemeanor to violate a rule or regulation of the Board of Agriculture regarding the marketing and branding of farm products. That's also a crime. And so Another reason why that first statement is false is that our crimes are not just peppered throughout the general statutes, felonies in 42 chapters, misdemeanors in 52, and misdemeanors in 142. They're also peppered throughout the administrative regulations and rules as well. True or false? Even though it's not in the general statutes, it's a crime in parts of North Carolina to let chickens run loose. How many people say well, apparently I'm throwing things all over the place. Let's see if I can fix that. How many people say that that's true? How many people believe that's true? Oh, how did you know this? How did you know this? You're catching on to the theme here, I think, is what's happening. It is true, and the reason is that in North Carolina, we delegate authority to counties and to cities and to towns and to metropolitan sewerage districts to make things a crime by way of an ordinance. So we have a town that has made it a crime to allow chickens or other domestic fowl to be at large in the town. It's a crime to do that. In another city, anybody here from Rocky Mount? Anybody here from Rocky Mount? Well, in Rocky Mount, there's an ordinance that makes it a crime if you have a business that fronts a paved sidewalk to fail to remove accumulated snow within 12 hours. That's a crime. In another, anybody from Mount Airy? Anybody from Mount Airy here? No? Okay. It is a misdemeanor for any person to use snap-and pops or silly strings within the corporate limits of the city. And I have another one. It's my personal favorite. But because I know here at the John Locke Foundation, there's a certain sense of decorum that normally applies, so I had to redact the photo to illustrate the next one. My redacted photo. Now, anybody want to take a guess at what's been made a crime through an ordinance with this one? Mooning. You're close. You're close. Again, we're on to the nudity thing. Think beach towns and attire, appropriate attire. Thongs, that is right. The town of Curie Beach. It is a misdemeanor to wear thong bathing suits or similar attire. Now listen, you may think that this should be criminal. I get it. But did you know it was? Did you know it was? And we're laughing and it's funny, right? But it's serious at the same time, and it's serious for a bunch of reasons. First, the criminal justice system is an expensive system. Because of the procedural protections that attach, it's a big deal to process conduct, regulate conduct through the criminal justice system. And when we're regulating conduct, like chickens and snow and silly strings and thongs, people have raised a question about whether that's the best use of public resources. Also, you do need to understand that even a misdemeanor in North Carolina isn't just about the misdemeanor. It's about a host of collateral consequences that attach to that person if they pick up a conviction. And those collateral consequences can interfere with a person's ability to serve in the military, get college financial aid, get a job, the checkbox on the form, have you been convicted, or qualify for professional licensure. So it's actually a serious thing to have a misdemeanor conviction, even if it's a relatively low-level one. And there's another issue that's kind of inherent in what we've discussed so far, and it's this. There's no central database for collecting all of the things that have been made criminal by administrative boards and bodies and by local governments, such that it's impossible to say today how many things we've made criminal in North Carolina. Now, that has consequences, other consequences as well. It makes it really difficult for people like law enforcement officers, prosecutors, public defenders, and judges to know and understand this vast amount of criminal law that we've created. And maybe more importantly, it undermines a really critical purpose of the criminal law, which is to give us notice as citizens as to what conduct is prohibited so that we can conform our behavior accordingly. True or false? We admit that we don't include everything in the general statutes, and we probably should do that. But when we do include it, we give you everything you need. We define the crime, and we tell you what all the relevant terms mean. How many people say that's true? Oh, you're catching on. How many people say it's false? You're catching on. So in addition to failing to include all of the crimes in the actual criminal code, because again, we allow them to be created by regulations and ordinances, when we include stuff in the crimes, we sometimes don't include everything that's needed. Put another way, there are just a lot of missing pieces in our criminal law. I'll give you a few examples. One, we in North Carolina recognize a whole bunch of common law crimes that have never been put in the code. These are things like common law robbery, arson, burglary, manslaughter. We're not talking about little stuff like thong bathing suit stuff. We're talking about pretty serious crimes that haven't been codified in the criminal code. Additionally, in North Carolina, we recognize principles of liability like aiding and abetting. It's not in the criminal code. Same thing for what we call general crimes like conspiracy and attempt. They're not codified in the code. Same thing with defenses like necessity and duress. They're not codified in the code. There are more missing pieces. For example, a lot of our criminal statutes don't say what the mental state is, the mens rea is, the bad mental state that's required for the crime. Or if they say it, they don't define it. Or if they say it and they define it, they don't tell us which elements of the crime that it actually applies to. Nor does the code define other key terms. For example, in our assault statutes, we've got a whole bunch of offenses that cover assaults inflicting serious injury and with a deadly weapon. Those core terms that apply that are elements of the offense aren't actually defined in the criminal code. And this matters. This matters. It creates problems. It creates really quite a number of problems. First, this is a lot of uncertainty and ambiguity. And uncertainty and ambiguity for lawyers is good because it means litigation. But for the system, it's expensive. It's expensive to have all those open questions. And the failure to define those key terms can at the same time cause some people to be held criminally liable when that's not what the General Assembly wanted, but it also can allow people to escape liability because the general rule is strict construction of the criminal law. So some people could be escaping liability because of that ambiguity when in fact the General Assembly wanted them to be held liable. And another thing that happens is when you've got all these missing pieces, it delegates the authority to the judges to decide on a case-by-case basis, which means you may get one ruling in county X and another ruling in county Y. And those are issues that we should care about. True or false? All right. We admit that we don't put everything in the code. And we admit that when we do put it in the code, we sometimes fail to define stuff. But what we don't do is we don't make it overly complicated. Anybody want to say true? Anybody want to say true to that? Well, that would be optimal, right? That would be the preferred answer, but I'm guessing you all are going to say false on that. And, so we've seen that, yeah, the code is missing pieces, right? And it's so weird that it's missing pieces, and at the same time, it's also incredibly complex. Let me give you an example. We can have situations where only one crime is needed, but we don't stop at one crime. We create multiple crimes. Let's look at an example. Let's look at the general crime of larceny. The crime of larceny is you steal someone's stuff. Okay, it's a generic. If I stole your sweater or your pocketbook or whatever, your briefcase, it covers all that stuff. It's a general crime, it covers everything. But we don't stop at just having a general crime of larceny that actually covers stealing someone's stuff, anything. We actually have enacted a separate crime of larceny of dairy crates, milk crates, one for larceny of motor fuel, one for larceny from a construction site, larceny of secret processes, technical processes, larceny of public records, larceny of wills, larceny of ungathered crops, larceny of, anybody know what that is? Ginseng, larceny of ginseng, larceny of pine needles and straw, larceny of portable toilets, and since we're coming into campaign season, larceny of political signs. Does this matter? Well, larceny covered all that stuff. Do we need 12 offenses when we already had an offense that covered the conduct? When we do this, it creates complexity. And again, complexity in a system that's as big and as complex as the criminal justice system means what?
Full employment for lawyers.
Full employment for lawyers, which is another way of saying it costs money. That costs money. And the public funds the criminal justice system. We could criminalize all of that with one crime, but we don't. We don't. We have all these separate crimes that cover it. Next question. True or false? I pass a worthless check to a merchant to get goods. If the worthless check is in the amount of $50. $50 is a worthless check. True or false? I can be prosecuted for both passing a worthless check, a misdemeanor, and obtaining property by false pretenses, a felony under North Carolina law. What do you think? It is true. I can be prosecuted for both. I can be prosecuted for both. So one other thing that's happened that's made the law really complex is that as offenses have proliferated, we have multiple overlapping offenses that cover the exact same conduct. If I pass that worthless check, I can be charged or convicted of worthless checks, a misdemeanor, or a felony, obtaining property by false pretenses. And when a single act can be punished in multiple different ways, and I give you a really simple example. If we had gone into the drug area, I could have given you a fact pattern where you could have 7 different crimes that would cover the exact same conduct. But what that means is that you can get, wildly different results for defendants based on which offense they are charged with. If you had one offense that was properly graded, which is just a crim law way of saying punished, you could just have one offense that covered the conduct. You wouldn't need multiple overlapping offenses with different elements and different levels of proof and different charging language that has to go to trial. There's another problem with overlapping offenses, and that is this, that the prosecutor has tremendous discretion in our system. And when you have multiple offenses that can lead to wildly differing results, the system can be perceived as arbitrary and unfair. And that can undermine the rule of law and the moral authority of the law. And that issue comes up in other ways as well in the criminal law. And it comes up in situations where the state can choose whether they're going to lump a bunch of conduct together for one charge or divide it into multiple ones. And I'll give you a simple example. You take $5,000 5 times over the course of 5 months from your employer. It's all part of the same kind of embezzlement scheme, right? It's embezzlement. It's a Class H felony in North Carolina. Well, the way the law works is the prosecutor has the option of lumping that together, because it's a continuous transaction, in one charge, in Class H felony, or 5 separate charges, and that can have tremendous consequences, because for the defendant who gets the one charge, and let's make him a pretty serious defendant, his sentence is going to be about 60 to 29 months because it's one charge. But for the defendant who gets 5, he gets 5 of those sentences that we call boxcard, runs consecutively of 16 to 29 months. Add them up. That's a huge difference in time due to just a discretionary decision about whether the prosecutor decided to lump it all together or separate them out. But here's the other thing. I don't have a problem. Prosecutors need discretion in operating the criminal system, but the way the law is it's like, why for this offense? Because, for example, we have a statute that makes it a crime for a felon to possess a firearm. So if I'm a felon and I have 100 semi-automatic weapons, I buy them and I have them in my house for a month, and then I get busted with 100 of them, it's just one. That's one. But this can be 5. I'm not saying how it should be, whether it should be one or the other, but it should be consistent, shouldn't it? We have these weird exceptions that just don't seem to make sense. Now, this proliferation of offenses has caused other problems as well. As we just keep adding, kind of engrafting offenses on top of what's already there, it leads to a tremendous amount of confusion and errors and reversals, which lead to injustice and wasted time and costs. As a matter of fact, we started adding so many, there's seats up front. We have added so many offenses, for example, into our sexual offense statute that a case went up to the Court of Appeals, and look what the Court of Appeals had to say. We strongly urge the General Assembly to consider renumbering the various offenses to make them distinguishable. There's no uniformity in how they're referenced. efforts to distinguish them leads to confusion. We don't see an end to this until they amend the statutory scheme. Well, the General Assembly complied, and they actually reorganized those sex offenses, but this same problem exists with other categories of offenses in the code as well, where again, there's so much confusion about which one, and is it subletter A or big letter B, or it just leads to all kinds of mischarging problems, problems that discovered at trial, problems that get discovered on appeal, or maybe they don't even get discovered till later in the post-conviction stage. The law is also inconsistent. And I could give you a lot of examples. I'll give you a really simple one. So there's a statute that says if you're tried for obtaining property by false pretenses, that's basically like fraud, getting somebody's stuff by fraud, you can't later be charged for a larceny or embezzlement. Okay. But if you're tried for a larceny or embezzlement, you can be charged for obtaining after. It just doesn't make sense. There doesn't seem to be any reason why that's the case. And the law is peppered with all kinds of inconsistent rules like this. But you know, you've listened to me long enough. It's time for you to answer another question. All right, here's the statement. Our code contains multiple provisions that have been held unconstitutional by the state and federal courts. How many people say that's true? How many people say that's true? All right, yeah, everybody's getting on. That is in fact true. We have multiple provisions in the code that have been held unconstitutional. Here's one. This is in one of our sex offenses. It's a statute that says if the defendant is convicted, the court can sentence to an elevated term if it finds egregious aggravation. That was actually unconstitutional when it was enacted. But what happened is a trial judge, busy trial judge who's handling a lot of matters, followed the statutory procedure. The case went up on appeal. And our appellate courts had to say, no, that's unconstitutional, but it's still there. It's right there in the statutes. I've got statutes with me, so we can verify that. So that's one example. There are other ones. Just one other one is there's in the statute on harassing phone calls, there's a provision about indecent language on the phone. Been held unconstitutional, violate the First Amendment. It's still there. It's on the books. And that's just not a procedural issue. That's actually a really serious issue, right? Because when we fail to repeal provisions that have been held to be unconstitutional, and you can quibble, who has to hold? Does it have to be the U.S. Supreme Court or Supreme? Okay, fine. We got them all, though. They're all in there. But when we fail to repeal those provisions, when they've been held by the higher authorities to be unconstitutional, we get error, like in the case I talked about where the judge followed the sentencing scheme because it's what the statute says. We waste resources because now the case has got to go up on appeal and then it's got to come all the way back down again. And maybe more importantly, we're violating people's constitutional rights. True or false? It's a crime in North Carolina to allow a female dog to run at large in the erotic stages of copulation. How many dog owners do we have in the room? How many dog owners? Okay. What do you think? Is it true? Is it true? Or am I punking you? Am I setting you up for a fall here because you got too confident? It's true. It's true. Now, this one is not in Chapter 14, Criminal Law. This one is over in Chapter 67 entitled Dogs. And again, because of the decorum, I'm not going to read you the title of the statute, but you can see it there. It's right from the statute books. I mean, I just pulled it right from the law. Now, I will admit something to you now. I'm supposed to be an expert in criminal law. I actually wrote the book, The North Carolina Criminal Law, with the supplements, about 1,000 pages long. See, it's my name. I did write it. I didn't know about this provision until recently. I didn't know about it. So if I'm an expert in criminal law and I didn't know about this provision, how is the regular citizen supposed to know that this conduct is prohibited? Remember, a primary purpose of the criminal law is to provide notice to citizens of what conduct is prohibited. So the problem here is that we've got laws on the books that are not in accord with what people thought was criminal. Did anybody know about that law about the female dog? Did you know? A couple of people knew? All right. You knew about it? Okay.
I think that's a double standard. What about the male dog?
I'm guessing the question is what about the male dog? I'm guessing it has something to do with the disruption that's caused when the female dog in the erotic stages of copulation runs in the street. So that's a problem. That's a problem. I wouldn't have, I'm not a dog owner, but I didn't know that. The other thing is we've got laws on the books that probably aren't in accord with contemporary standards of behavior. We have a statute on the books called fornication and adultery, and it makes it a crime for a man and woman who aren't married to each other to live as if married. That means habitual sex. So that's basically criminalizing living in sin. Now let's set aside the fact that this presents all kinds of constitutional issues, but it's on the books, and question whether it's in accord with what people think should be criminalized today. The other thing is that we've got new statutes, a bevy of them, that are created and they're actually never used, raising real questions about whether we need them to be on the books at all. For example, in 2009, there was a statute, the porta potty statute. We talked about this a little bit. It basically said not only is stealing a porta potty a crime, but destroying one or vandalizing a porta potty, I guess this was a big issue, is a class 1 misdemeanor. Now, 1 misdemeanor may not sound that bad, but 1 misdemeanor is actually pretty high in terms of our misdemeanors. But anyhow, that was already a crime. Remember I talked about the general crime of larceny? It already covered stealing stuff. Covers stealing any stuff, including portable toilets. And injury to personal property was already covered at the same level under the injury to property statute. So not surprisingly, another crime was added to the books and it sits there unused. Because we already had statutes, and this one's actually a lot more complicated to charge, and the elements are a lot more specific, so why would the state use it? Now, talked about a lot of things. What's at the root of the problem with all of this? Well, you may disagree. I have a feeling you're going to pipe up and tell me if you do. But my view is the root of the problem is that North Carolina lacks a streamlined, comprehensive, orderly, and principled code. Now, what do I mean by that? Well, first, by streamline, I mean it doesn't include all that extra stuff that we don't need. It takes out all the things that are unnecessarily, making the code unnecessarily complex, redundant provisions. A comprehensive code means it includes everything we need in there. It defines all the core crimes in one place. It tells us what all the elements are. It defines the required mental state, etc. An orderly and principled code is one that's internally consistent. It doesn't suffer from those oddities that we talked about, where things you just sort of scratch in your head thinking it just doesn't make sense. It complies with the Constitution. It makes efficient use of public resources. And again, the lack of this matters. We've touched on most of the reasons, but first, unnecessary complexity. I mean, think about the law enforcement officers and the magistrates and the prosecutors who are trying to figure out what crime to charge. And they can't just charge larceny. They got to figure out, well, which flavor of larceny it is. Is there a special flavor? It's hard to remember what all the special flavors are. It makes it really hard for charging. And all of these overlapping multiple offenses, every one of them has different elements. So when we go to trial, it makes it hard for the prosecutor who's got to make sure they have the right proof, the defense lawyer who has to mount the defense, the judge who has to preside over the trial, the courtroom staff who prepare the court records, the court system who has to prepare all the codes, the offense codes and the forms and all the things that are necessary for processing cases when you have multiple overlapping offenses, some of which we need, many of which we don't need. Also, all of this, obviously, we've talked about the issue of the unnecessary cost. And the cost, I mean, we touched on, it's not just the training issues and the time, but it's also the mistakes and all the extra processes that have to get created when you've got something that's unnecessarily complex. We've talked about the issue of wrongful convictions and acquittals. And listen, both of these pertain to public safety because, you know, a wrongful conviction is a harm to the person and their family, obviously, and the integrity of the system, but it also means that the real perpetrator remains free to perpetrate crime on other people, and folks often forget about that. The ambiguity leads to inconsistent application of the law in the trial courts that can be perceived as arbitrary, again, undermining the law. The lack of notice. You can't read chapter 14 and think you're going to know all the crimes in North Carolina. Not only are they peppered throughout the general statutes, but they're crimes created, as we saw, in the administrative regs and in local ordinances. And we've talked about the issue of how Some of these features of the code can lead to wildly unpredictable results. So inefficiency and costs for sure, but perhaps there's something that's more important, at least to me, and that's that I worry that at the heart of this messiness in our code ultimately undermines our criminal law. It undermines the integrity of the law, trust and confidence that we as citizens can have that the law is going to be fairly and consistently applied, the moral authority of the law, and ultimately the criminal law's ability to serve as an effective deterrent to conduct. So, what do? How do we fix it? Well, I'm sure there are a lot of ways that we can do it. One way that I'm particularly interested in and have been talking to people about is to do something called recodification. And recodification is basically a fancy word to refer to a comprehensive rewriting of the code to create a streamlined, principled, orderly code. The primary goals of recodification include everything you need in there. Make sure you got all your key crimes, make sure you've got all your key definitions. Take the stuff out that's not needed. Eliminate all the redundancy and the stuff that's making it overly complex. Use plain language that normal people can understand. This will also really help law enforcement officers who are on the scene in the heat of the moment are trying to figure out how they should process a particular crime. Make sure that it's consistent and rational. Those are the issues that we've already touched on. And preserve the legislative judgments. In other words, the General Assembly has already made decisions that certain things should be made criminal, and that those judgments can be preserved in a recodification process. Not only the legislature's determinations, but also determinations that our appellate courts have made about the current law. So it's a cleaning up process, but preserving. It's not about being soft on crime. It's about being smart on crime. It's about doing it in a way that's clear and gives better notice, and ultimately can help with implementation, the efficiency, the fairness of the administration of the criminal justice system. Y'all have been pretty quiet throughout this. Now's the time. What do you think? No? Go ahead.
The problem is the lower level, the lower layers. For example, if you're Cary, suppose the town of Cary says, by the way, at sundown, everybody has to have a porch light on to improve safety in the community. Well, how does it all, I mean, every town can do whatever they want. How are they going to be able to abide by any guidance when they have free rein to do what they want?
So the question, the concern here is really about the ordinances, the crimes that are created through an ordinance. Well, in North Carolina, that's because a statute does that. You don't have to have that statute. You could decide, the General Assembly could decide as a policy matter that it makes more sense to enforce certain things, like your example was failure to turn a porch light on after sunset, through a fine system, not through the criminal justice system. There may be other things that exist in ordinances across North Carolina that we all agree, the General Assembly agrees and society agrees, you know what, that actually should be a crime. Let's put it in the code then, right? Yes, sir.
Would you allow, to add on to that gentleman's question, would you allow these smaller municipalities and counties and so forth to continue to make laws if we recodified North Carolina's system?
So the question is, would you, meaning me, allow municipalities to continue to create crimes through the local ordinances? Well, when the beautiful day comes that I am queen for a day, and I have been looking forward to this day for so long. Of course, that's not my choice, but one reasoned policy question is, what should we allow to be made criminal through ordinance, and should we allow things to be made criminal through ordinance, or should it all be part and parcel of with the General Assembly? Because if you did this great cleanup of the criminal code, it could also fall to pieces very quickly if a proliferation of crimes can continue through those other ways. So that's something at which reasonable minds could disagree, but that's a conversation that we ought to have. There may have been a good reason why that provision was put in the general statutes that allowed things in violations of ordinances to be a crime. There may be a good reason. maybe it's time to ask the question, does that make sense now? Should we take a look at those things and decide, are there things that are so serious that they should be in the code, and the rest of it maybe we should deal with in a civil? I'm not making a judgment one way or another. I just think that's a conversation we should have. Yes, sir.
Do you feel that having so many duplicitous laws allow for individuals to be double charged for the same crime?
So the question is, do I feel that having so many duplicative laws allow people to be double charged for the same crime? Well, there's almost a little bit of a judgment in that question, but the fact of the matter is, in many instances, the same conduct you can be charged and convicted of multiple offenses. And you know, possession of drugs is a great example. If I possess a felony amount of drugs, like I possess 2 ounces of marijuana, that's possession of under 1.5 ounces of marijuana is a misdemeanor. 2 ounces is actually a felony. I can be charged with possession of marijuana. I can be charged with potentially with possession with intent to sell and deliver, depending upon other conduct. I can be charged. If I actually did the sale and delivery. I can be charged with a sale, and I can be charged with a delivery. If we make it a larger amount, I can be charged with all those things, as well as trafficking if it's over 10 pounds. I mean, there are lots of instances where a defendant can be tried and convicted for multiple offenses, and that issue has gotten so confusing that in this book, oh, it hurts my shoulder to lift it up. In this book, I actually and this doesn't cover all the crimes, by the way. This isn't all the crimes. This is just the most common ones. So in this book, I actually, in the last edition, this last edition in 2012, I actually added notes to the crimes, multiple punishment and conviction, to clarify for folks when that's the case. Now, sometimes the General Assembly, when they enact a statute, they do a beautiful thing. And they say, unless punished under a provision carrying greater punishment, it will be. And that makes it clear you're only going to have one conviction if you've got multiple offenses, but that's not the case generally. Yes?
Is there a state that you can point to that has done this and has done it well?
So the question is, there is a state that's done it and has done it well. And it's a little bit of a complicated way to answer that. There have been sort of 2 phases of this work, this recodification work. Back in the 60s and 70s, there was something called the Model Penal Code, which came about, which was meant to be sort of a model statute on criminal law. And a bunch of states enacted that at that time. We're not a Model Penal Code state. And so there was some cleanup, although even in states that did it, they've kind of deteriorated since then. There have been, as far as I know, at least 4 states that have undertaken recodification efforts. But I think there's one that's still pending, and the others weren't that successful. And I actually spoke to the people that were involved in that, and part of the reason is they didn't have the right stakeholders at the table at the time. This is a big undertaking, and it's an undertaking that really requires consensus work by really all of the justice system stakeholders. It can't be done by one side, right? So you want to have the prosecutors and the defenders, and you want to have the trial judges, you want to have the appellate judges, and you want to have victims advocates, and a whole host of justice system stakeholders involved. So for example, in one state that undertook it and produced a big recodification report, the prosecutors weren't involved. So it didn't go anywhere. So no big surprise. So other states have tried, and we haven't seen a tremendous amount of success, certainly in the second phase since the Model Penal Code reforms. Yes, ma'am?
How much has the conflicting political interests of towns and municipalities and state government created a barrier?
So the question is, how much does conflicting interests from towns and municipalities and state government created a barrier? I don't know the answer to that question. I don't know. It's an interesting question. I've wondered about that. If anybody has any wisdom to share, please go ahead and share it. Yes, sir.
Not on that, next time.
What's that?
I got another question.
Sure. Go for it.
Just in your presentation, you talked about a central database to gather all this information in one place so people can find it. I know you didn't address that in the solutions directly.
Well, I mean, if we did recodification the way, you know, again,
If you're going to maintain the states and the counties and
or
we're
you
still the same.
or you change that, or you change. I mean, listen, you know, the hard part about, well, recodification is kind of like this sort of a project, right? You know, I know there's some people who say you can't do it, it's too big. I actually think you can do it. It's just you have to do it one piece at a time and take your time and do it with care with the appropriate stakeholders. But your question raises a really important issue, which is that it's not going to have any lasting value unless you have some kind of a control mechanism on the back end so that it just doesn't deteriorate. And there are a number of mechanisms that one could think of, which is perhaps having some additional having limitations or procedures for anyone other than the General Assembly creating crimes, and maybe having some kind of a process for when the General Assembly wants to create crimes that maybe they get feedback on whether the conduct is already covered, and those kind of things. And those are suggestions that folks have talked about that are interested in this work. I think, did you?
Can you just talk a little bit about sort of home rule versus dealing rule, and the idea that the effect that that's had on overcriminalization? If basically the idea that in North Carolina, as I understand it, that a local government has to point towards some state statute in order to pass a local ordinance and sort of hang it around there. But I'm not sure sort of how rigid that standard is, and if it really just it's sort of so loose that you can point toward any statute at all, and so that it's really not going to limit overcriminalization.
So the answer to your question is that there's actually a statute. I think it's 14.4a. I could check because I have my red book, that basically says violation of an ordinance is a class 3 misdemeanor. So that's actually, that's an easy fix. Now the ones for the administrative boards and bodies are a little bit different because they're sort of peppered throughout. So if what you wanted to do is you want to constrain the ability of local governments to make things a crime, not to regulate it, but what you wanted to do as a policy matter is that I don't think that part would actually be that hard. But kind of in your question, there was another issue which I didn't even touch on, which is that sometimes we have session laws that pass the General Assembly that create crimes that only exist in certain places in North Carolina. Like there are these like weird third-degree trespassing crimes for like trespassing involving hunting that only apply in certain counties. I used to try to keep track of them. I couldn't do it because they're not codified. They're just created in the session laws. So that's sort of a whole separate issue, but those are going through the General Assembly. So on the municipal ordinance and stuff, I actually think that's something that could be accommodated. Yes?
Do you think
Sure.
the first order process in this, like in order to enact change, would be to create a system or database where you could like check on these or compare these things?
So the question was, well, what about a first stage where basically you create some kind of index of everything that's been made criminal? I know that folks are interested in that. And that would be really interesting. It would be really great to actually see everything. So in terms of stuff that's in the code, we already have this. We have a sentencing commission, and they pretty much have a catalog of every provision in the code. But with respect to administrative boards and bodies and ordinances, that would be really interesting because that would be a way for people to comment and look at this behavior and maybe see some of it, like what you're talking about, that just seems, this is crazy, this shouldn't be criminal, and then they could perhaps see other things that they think, wait, this is really serious, this should actually be in the code to apply to everybody. So that would be one way to have sort of the ocular proof of what it looks like. Yes, sir?
One last question. Have you looked into the arguments in particular cases for creating some of these redundancies? Let's say, the stealing of a
Porta potty. Yeah.
Right. Were arguments made that, hey, look, it's already a crime. Why are we doing this? And in conjunction with that, who are making the arguments? Are there special interests involved that make benefit from the making it an additional crime?
So the question's getting at why do we have some of this redundancy? And I haven't done an empirical study of this, but I certainly know of instances where it is certain industries or groups that want certain coverage. But there, we talked about the issue of you could do this beautiful recodification, it could get messed up on the back end. And so I've had a lot of conversations with people about, well, how could you do this? Well, what if you had the code and then you had an official commentary? And so a legislator has a question from a constituent who's maybe in the construction industry who wants to have harsher penalties or have a special offense for stealing from a construction site. Well, can add it to the official commentary. This crime of larceny covers stealing from a construction site. So it's not an additional crime, it's in the commentary. Will that work? I don't know. But it's an idea as to one way that folks can feel responsive, folks can be responsive to their constituents that want it clear that something's covered, and at the same time is not creating something that's a new crime. These are all issues. I don't have all the answers on this stuff. That's the hard stuff. Well, it's all hard. Doing it's hard, but the harder part is on the back end, keeping it clean. And if y'all have brilliant ideas about how to do this, please let me know, because I'm all ears and I really do want to hear them.
Final question to Becky.
Becky.
Thank you so much for talking about this
Well, the question was, what is my sense about the appetite? All I can say is that I've spoken to a lot of people, and the only objection that I've heard from any group, and that's whether it's prosecutors or defenders or judges or anybody, is this one. The concern is just too big to take on. I haven't heard anybody really have a substantive concern about the actual work, and most people see the tremendous benefits from it. I'll leave it to the advocates to take it to the relevant policymakers and see where it goes in this or later sessions of the General Assembly. Thank you.